Yes, ma'am.
What all exactly is probate?
Probate. Let's get that. Probate is, the word probate itself means the probate of a will, which is proving the will to be valid upon someone's death. Now, years ago in Georgia, the probate court was called the Court of the Ordinary. Not exactly sure of the origin of that term, but it was kind of a hodgepodge of, it was like a melting pot of everything nobody else wanted to do. The probate court did. They did cattle brands, they did marriage licenses, firearms licenses, fireworks permits, probate of estates, guardianships, mental health matters, and things like that. Back in the late 70s, the title changed to probate court, but the duties of the probate court are very vast. They're very broad. There's many different things. They're, for the most part, administrative functions, and some of them you may never have opportunity to use or even know about. But the main thing people think about is decedents' estates, wills, administrations. We have a unique procedure in Georgia called a year support. That's a spousal support after someone dies. No administration necessary. We do guardianships. We do guardianships of children. We do conservatorships, which is handling money of children or adults. We do guardianships of adults. That is my specialty now. I hear all of the adult guardianship cases in Fulton County. I have for 5 years. I also hear citations of fiduciaries when we have an executor, an administrator, a guardian, or a conservator who has gone astray. It is my job to call them into court and to hear the case and determine what the proper remedy is. How bad is it? And do we need to take them out of office or in their judgment, that kind of thing. So it's been a wonderful experience for me the last 5 years. I've always been behind a desk, and now all of a sudden I was in a courtroom, but it rounded out the experience. I think what people most often deal with probate court is probably getting a marriage license or a firearms permit for a concealed weapon. In Fayette County, which is a little smaller than Fulton County, a lot smaller than Fulton County, they have certain duties that Fulton no longer has. The Georgia law says that any county with a census-designated population over 96,000 has special jurisdiction. They can do jury trials. They can do certain trust matters. Fulton has that power. I can have a jury trial if I need to in Fulton County. Fayette does not have that power. However, with the next census, Fayette will clearly be over the 100,000, the 96,000 mark, so probably over 100,000 now, but it won't become official. So there's going to be expanded jurisdiction in the probate court with the next census, probably a year or two after 2010. And the duties will change. The probate judge will have to be an attorney. Right now, the probate judge does not have to be a lawyer. But are there any other questions about this?
Just one which I hope would have a short answer. I don't understand why it has to be a partisan position. I guess because you have to be elected and you have to be on one of the party rolls or something?
It simply is by statute at this time. Several of the probate courts, well, about 1/3 of the probate courts in 159 counties in Georgia, by special legislation, have been made non-partisan races. As an example, Fulton County probate judge is a non-partisan race. Fayette is not there yet. And there's a lot of reasons for that, but it used to all be partisan. And then county by county, it becomes nonpartisan as legislation is passed.
Would there be some ideological differences in the way you administer the court?
No, none whatsoever. And that's a significant point. This is a judicial position. There are a lot of administrative functions, but it boils down to, even as an associate judge, I am a judge. I am subject to the rules of the Judicial Qualifications Committee. I am subject to special judicial ethics in this election. I mean, I've got special rules that other folks don't have to follow with the elections. I have to be very careful. One of them being, can I join a political party? I have to research that. I don't know if I can or not, but I have to be very careful with what I do. So no, I mean, you've got to do it a certain way. You apply the law as it is written and as it's interpreted by the appellate courts, and that's the same.
Thank you.
Talk a little bit about what my specialty is, which is adult guardianship. And I don't want to.
What is that?
Adult guardianship. There's also what we call conservatorship. So just so you'll know, an adult guardian is a person who takes care of the health, welfare, and placement of an adult who has been found by the court to be in need of a guardian. Now, only the probate court can adjudicate someone in need of a guardian. A conservator is the person who handles the finances and assets of a person who the probate court has adjudicated in need of a conservator. In other words, they're not able to handle it. They used to use the term incompetent. That was not politically sensitive or correct. So then the term was incapacitated adult. And a few years ago it changed to, we did away with incapacitated adult. You're now called a ward. A proposed ward is a person who is believed to be in need of either a guardian because they can't manage their own health and welfare, or a conservator because they cannot handle their finances. Some of you may have heard the term guardian of the property, guardian of the person. Those terms are now antiquated. Just a show of hands, has anyone served as a guardian or a conservator for anybody? No.
I would not have thought of guardian. No, I would say I had
Custody?
no, but we had we were able to make financial decisions for our mother.
Okay, did you have the power of attorney?
Yeah.
And see, here's the key right there. That's going to be the root of what my talk is going to be about, is the law provides that there's a legal procedure to have a person appointed to help an adult, that's anybody over 18, who for whatever reason cannot handle their affairs. But that's a last resort. You don't want to have a guardian or a conservator appointed unless you absolutely don't have any other alternative. The law views it as the last resort. What most people do if they are knowledgeable and have access is they will make plans. They will have a durable health care power of attorney. They will have a financial power of attorney. They will have assets held jointly and jointly with right of survivorship, joint bank accounts, things like that. But there are times when you have to come to the probate court. Case in point, let's talk about my dad. I love my father. He went to law school for 1 year and thought he knew everything. He was a civil engineer by career in the Air Force, and decided when after he retired he needed to be a lawyer because none of his kids would go to law school except me. So he went to Woodrow Wilson Law School in Atlanta and completed 1 year and then quit, and then thought he knew everything. Well, my grandmother got dementia, and she lived up in South Carolina. My uncle was nearby and took her to a lawyer and had a power of attorney executed. Well, that did not bode well with my father, who thought he knew everything, and he was a wonderful man, but he knew just a little too much. So he then goes, visits my grandmother, takes her to another lawyer, and has her execute another power of attorney. So now we've got the dueling powers of attorney, and we're starting to get sibling rivalry, a little bit of sibling rift. Now in that case, fortunately, they were able to work it out. My uncle and my father and my grandmother sat down. They realized my grandmother was capable still of making certain decisions. They agreed on who would do it, and it worked itself out. A lot of times that doesn't happen. The parent may be well beyond being able to make the decision of to who will handle their affairs. And you've got battling power of attorney, you come to the probate court. Somebody petitions for the appointment of a guardian or a conservator so that they can figure out who's going to be in charge. I mean, you can just imagine. You have doctors who may be confused because you've got different children saying two different things. You've got banks. Somebody walks up with mama and the power of attorney, and then the next day another person walks up with mama and the power of attorney. So there's certain circumstances where it's just inevitable that you've got to come to the court.